Thank you very much. Thank you very much for invitation. I'm glad that so many people are interested in human rights and this Central and Eastern European approach on this. It is always the problem on thinking on human rights, because human rights are based on the values, and these values should be common, and sharing it regionally could be difficult. So today I would like to speak about this protection on fundamental rights as one of the foundations of modern constitutional democracy and the rule of law. In Central and Eastern Europe, the subject has a very particular importance, and that is mainly because of the region. Historical experience, it was said during this discussion panel. In Central and Eastern Europe, the subject has a very particular importance, and for decades many states in this part of Europe functioned under a communist regime. In those systems, violation of rights and freedoms were not occasional. They were structural, and they were part of the how the system worked. Of course, there were constitutions in these communistic countries, but the meaning of the constitutions was different than in democratic states. So when constitutional transformation began at the end of the 20th century, it was not only about political change, it was also about rebuilding the legal and axiological foundation of the state. And people fight for their rights. The strikes, for example, in Poland, were about the quality of life, social rights, and so on. So it was not only about the political system. And one of the most important elements of the process was the protection of human rights. At the same time, although fundamental rights are rooted in shared values and reflected both in natural law traditions and in international legal instruments, their constitutional expression is not identical everywhere. Different states define rights differently, and they organize them differently, they interpret them differently, and they also protect them through different institutional mechanisms. So this brings us to the main question of today's lecture. Can we identify a common standard of fundamental rights protection in Central and Eastern Europe? Remember that, for example, in some of the countries of the region, these countries were the members of United Nations. The pacts of human rights were ratified, but it was very often only on the paper. And to answer the questions, I will rely on the comparative analysis of selected constitutional systems: Bulgaria, Croatia, Czech Republic, Hungary, Poland, Romania, Slovakia, and Slovenia. Of course, I don't want to tell you about each country, how it is in Bulgaria, Croatia, and so on, because these are the subjects for separate lectures. But I would like to make it a comparative approach. And how do you think? Why this comparative constitutional analysis is useful for us? I would like to interact with you. Why we are here and make comparative analysis of the constitutional system, human rights system? Why it is good to know how some human rights are regulated in Poland, Hungary, Croatia, Serbia? Do you have any ideas, please?
So you can see the good practice there, both from relations of human rights, and you can see what we can implement from other countries.
So,
similar with culture of other aspects.
Okay, we have similar culture background, for example, and according to this comparative approach, we can compare this institution and see what is good, what works, what does not work, and we can implement some solutions to our system. Okay, something else? So, please.
We can determine which solutions do not work and avoid them.
Yes, we can determine which does not work, and we can avoid them, not implement them, and then. Yes, of course. And do you think that it works always? Because maybe sometimes something does not work in some countries, not because it is bad, but because the application of the provision is bad. So.
Sometimes it's always the issue of compliance, so maybe we can check also how to comply with certain solutions, and we can also determine which solutions are easier to apply, let's say, and which work and which do not.
Yes, so because of that, when we take this comparative constitutional analysis, we should know that we should analyze not only the provision of the legal acts, but also practice, judgments, also legal scholarship thoughts, and all together can give us the picture of the system, not only analysis of the provisions of legal acts. So, to sum up, this constitutional analysis is useful because it helps us to identify similarities and differences. It allows us to assess how different legal systems respond to similar problems. And third, it helps us reflect on which institutional solutions are most effective in protecting individual rights. So we will focus today in some particular elements of this protection or picture of human rights protection in Central and Eastern Europe. First, the concept of fundamental rights, then constitutional regulation, relationship with international law, because it is also very important, and then the limits of protection and access to effective remedies. So the aim of our meeting today is to present a synthetic overview of how fundamental rights works in the region, and second, to assess whether, despite the visible differences, we can still speak of a shared normative standard. I don't know. So, the concept on fundamental rights. Before we analyze the constitutional status of the individual, we need to ask something more fundamental. What do we actually mean when we speak about human rights, rights and freedoms? Because in legal language, terms such as human rights, fundamental rights, constitutional rights, and civil rights are often used almost interchangeably. But that can be misleading. because in many legal systems, these terms do not mean exactly the same thing. And those differences are not merely semantic, they may affect legal interpretation, judicial reasoning, and the practical scope of protection. If we look at Central and Eastern Europe from the comparative perspective, one thing becomes clear very quickly. There is no full terminological uniformity across the region. In some countries, such as Bulgaria and Romania, we can see a relatively clear distinction. Human rights are understood as universal rights linked to human dignity and often connected with international law. So these human rights are connected with international law. By contrast, constitutional or fundamental rights are rights guaranteed with the domestic constitutional order. And it is developed also in scholarship thoughts. The scholarship distinguishes not only between human rights and constitutional rights, but also between citizen rights and public freedoms. So the conceptual structure is quite refined. In other systems, for example, in Slovakia, these different expressions are used much loosely. Even if different terms appear in constitutional text, they are generally treated as normatively equivalent. So the text differs from the interpretation. For example, in Polish reasonings of Constitutional Tribunal, we have constitutional freedoms and rights, but very often Constitutional Tribunal also writes about human rights in the meaning of these constitutional rights and freedoms. Despite all these differences, there is also a very important common element across the region. It is European integration, membership in the European Union, together with participation in the system of European Convention on Human Rights. It has strengthened the role of the concept of fundamental rights, and I think that for the countries of the region, more important is European Convention on Human Rights than, till today, Charter of Fundamental Rights. Why? As I said, the change of the political system in the end of 20th centuries was not only the change of the political system, but also the approach of on human rights. And first, before these human rights were put in the legal act, this new constitution after transformation, constitutional courts, Supreme Courts, interpreted human rights via Convention on Human Rights. So even if there weren't written in this constitution, the provision of the domestic system was interpreted in accordance with European Convention on Human Rights. For example, in Poland, in early 90s of 20th century, there was in former constitution, communistic constitution. After transformation, it was amended, and article on a democratic state ruled by law was put, and Constitutional Tribunal from democratic state ruled by law interpret provisions on human rights based on European Convention on Human Rights. So it was very important, and it has also it had also influence on preparation new constitution. So to conclude this part, the language of rights still differs across Central and Eastern Europe, but there is a clear border trend toward conceptual and normative convergence. And in practice, these systems increasingly operate with a shared European framework of rights protection. And of course, English language is not so good to express our terms in our state constitution. And sometimes it is the problem to translate our local terms to English, legal English. And very often it could be misunderstood. For example, in Poland we have constitutional tribunal. For English language, it is something strange because we should call this court constitutional court. But in Poland, in Polish version, we said that judiciary is composed by courts and tribunals. So tribunals are something different than courts. They are judiciary, but they have different competencies, different responsibilities, and it matters. This term matters. And if we come into this international level, it is difficult to explain how it works in Poland. So we should take care of it, and it is very important that our members were in this international organization, international courts, to explain how it is understood, and it is this East and Central Europe approach to translate or transpose into international or EU law actions. So another thing very important are the sources of protection of fundamental rights. At the most general level, fundamental rights may derive from different normative sources, but in all systems examined there, the Constitution remains the primary and most authoritative one, and from a comparative perspective, we can distinguish three broad models. First, there are systems in which rights are regulated directly in the constitutional text, and it is the most popular version. Second, there are systems that rely on a separate constitutional document, as in Czech Republic, such as Charter or Bill of Rights. And third, there are systems in which international law plays a particular strong role, sometimes close to a quasi-constitutional one. But I think that in our region, it is not so popular. It is rather the Western approach, as for example it is in France. And of course, I would like to remind, in communist constitutions also there were Bill of Rights and Duties of the citizens, but they had very different character than this based on other sources. So in the Central Eastern Europe, one observation is clear. The Constitution is always the central source of fundamental rights protection. In most countries, Constitution contain extensive catalog of rights, usually organized in separate chapter of the Constitution. And I think that what is typical that these catalogs are very, 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 very wide. And importantly, these provisions are not merely symbolic, and here, for example, it is a problem of social rights, cultural rights, which were not so popular in these Western constitutions of the other countries, and in many cases, these provisions are directly applicable, which means that individuals may rely them directly before courts. It's a kind of shortcut because very often these provisions are so general that we don't know how to do it, and in my opinion, we should treat these catalogs as a standard for legislator to base other particular system of protection, particular rights made by the parliament. But maybe we can find, and you can find in your constitution such provision that could be directly applicable. Because what does it mean that I have the right to court? If I don't have the statute how to apply to the court, how the proceedings should look like, it is different. I can't do my legislation in our legal culture, common civil law culture, by myself. So we should be carefully here with these things. And some systems, however, use more complex structure. As I mentioned, in the Czech Republic, there is constitution together with Charter of Fundamental Rights. It's a separate act, but it makes a constitutional block with the constitutions. And freedoms and rights are integral part of constitutional order. This gives them a dual structure and also makes rights protection more visible and more internally coherent. And while making post-communistic countries' constitutions, it were always discussion if we need to make a catalog of human rights in the constitution, or should we come back to the beginning of the modern constitutionalism, separate provision on how on the state system and separate Bill of Rights. And we have in this Eastern and Central Europe thought this approach to involve these catalogs into the constitution has won. At the same time, constitutional protection today cannot be understood without international law. All analyzed states are parties of the major human rights instruments, above all, European Convention on Human Rights. And as EU members, they are also bound by the Charter of Fundamental Rights of European Union, but there are some exceptions of the scope of this binding. For example, Poland is such example. Another important element is institutional protection. Constitutional courts play a central role as a guarantors of fundamental rights, and also to develop the standard. In many countries, they are complemented by additional institutions such ombudsman, which helps strengthen the practice effectiveness of protection. And here we have this background, normative background in constitutions or this Charter of Fundamental Rights in particular states, but how we understood this human rights, it is up to the constitutional courts, but very often constitutional courts refer to judgments of European Court on Human Rights to explain how freedom of speech is understood, freedom of belief, fair trial, and so on and so on. So it should be complex. So what follows from this? Despite certain differences in the structure, the system of the Central and Eastern Europe show a relatively high degree of convergence, and the constitution remains the core source of protection. But it functions with a broader multi-level framework that also includes international law and judicial enforcement. And together, these elements create a model that reflects both national constitutional traditions and shared European standards, European values. It is how it should be, but the practice sometimes is different. And now, so if international law is important in shaping human rights and also in domestic legal system, it is worthy to note the status of international law in the domestic legal system. The effectiveness of rights protection depends not only on what the Constitution says, it also depends very much on the place international law occupies within the domestic legal order. And in Central and Eastern Europe, international human rights play a particularly important role. Why? Why, in your opinion, this role of, for example, the European Convention on Human Rights and Charter on Fundamental Rights is important in the countries of this region, or was important during this period of transformation? It is also this question about the thought on approach to the human rights in the region of Central and East Europe. Do we have separate thought about this human rights? What is your impression? I don't know if you follow me. Do we understand human rights as citizens of the states of the South, East and Central Europe region different than it is done in European Convention on Human Rights, jurisprudence of European Court on Human Rights, or maybe we received it to our system? Any ideas? Do you have practical? There is an impact because during communist periods, even if someone tried to research human rights, this research were based on this universal human rights system or regional system of the European Convention on Human Rights. Remember when that the requirement, for example, to be a member of the Council of Europe is to fulfill requirements on human rights based on European Convention on Human Rights. So it is natural to follow this thought based on the Convention and based on the jurisprudence of the European Court on Human Rights. But how it is formal? Because from a comparative point of view, we can treat the relation between international law and national legal system in different ways. Classical, there are two base theories of this relation: monistic model and dualistic model. Do you know about it? In monistic model, who was presented and promoted by Hans Kelsen, we have one legal system, and there is international law, domestic law, but there's no need to transform the international law to the domestic system because it could be applied directly. It is very simply, but it is the core of this system. And second approach is this dualistic, that we have two legal systems, international and domestic, by Heinrich Trippel. And when you want to use international law in your domestic system, you have to translate it, implement it in the way of domestic legal acts. So how do you think, which of those systems are applied in our region? Could international agreements, contracts, international contracts be applied directly in your countries? Or you should enact, for example, a statute by a parliament with the provisions of the international law? How it is in your countries? So after my research, there is one notice that rather we use this monistic model, but it is a kind of hybrid, because sometimes we can't direct use the international agreement in our legal system, so then we have to enact the statutes. But normally after ratification, these international agreements are a part of our domestic legal system and could be used directly in our practice. But now, today, we have multi-level system and many centers of legislation. So we have also EU, which status is different because the primary sources are rather from international law, but secondary are not. So it is difficult today to implement strictly monistic or dualistic system. We today are talking about legal openness or multi-level approach to relation between to international law and the national law. But in the constitutions of this region, in countries such as Bulgaria, Croatia, Czech Republic, Romania, and Slovenia, Poland also ratified international treaties, become a part of domestic law, and in most cases they also take precedence over ordinary legislation. In some systems, their law is even stronger. For example, in Romania, international human rights instruments, especially European Convention on Human Rights, have acquired a status in judicial practice that may be described as quasi-constitutional, and this clearly strengthens their protective functions. Not all states, however, follow a purely monistic approach, and some systems adopt mixed hybrid solutions, and in Poland we can say that we have monistic elements, but also this dualistic when we should enact the statute to fulfill requirements, obligations from the international law. And international treaties must first be incorporated into domestic law with reflex dualistic elements. But once ratified and promulgated, they may still enjoy priority over statutory law. And it is especially in the field of human rights. In some constitution of the region, it is clear written that international agreements concerning human rights are above statutory law, but they are not above constitution. For example, Polish Constitutional Court could judge if European Convention on Human Rights is in accordance in Constitution, and it is strictly written in our Constitution. At the same time, so Constitution remains the supreme law, and that means that the direct effect of international law may still be limited in the certain situations. But there are some structural differences. Constitutional courts increasingly act as mediators between domestic and international law. In practice, they often interpreted constitutional provision in the light of international standards. So international human rights law is not only formally recognized, it is actively integrated into constitutional reasoning. And not only the interpretation of convention, but also the provisions of the reasoning of European Court on Human Rights is also involved in this reasoning. What does this tell us? Despite the diversity of institutional models, all analyzed states acknowledge the major role of international human rights law. And more importantly, we can see a broader process of convergence. International standards no longer merely supplement domestic system, and they shape it. For example, when we are planning legislation, in the reasoning of the bill, we should assess if our regulation is in accordance with international law, if our regulation, if the bill is in order with international human rights standards. And now let's let's come to the details. And first, we should ask who is obliged to protect fundamental rights. Who is actually obliged to respect and protect fundamental rights. And again, English language is not so good to explain it, because the obligation to follow rights and to respect the rights are something different in theory of life. If we talk about respect human rights, so making decision on the basis on human rights, it is about the state bodies, about state entities, so public entities. And if we are talking about following fundamental rights and following law, it means that all of us should behave in accordance of law. And traditionally, constitutional theory distinguish between three models. First is a vertical model, and in that model, rights operate mainly in the relationship between individual and the state. Of course, the individual is not only the people, but also the entities of private law. It is more universal. So public authorities are primary duty bearers. The second is horizontal model, and the rights also influence relation between private individuals and private entities. And third is mixed model, which combines both approaches. How do you think, what kind of model is applied in your countries? Vertical, just horizontal, or mixed? On the base on law, not on the base of practice. For example, imagine that you are NGO organization in your legal system, and do you have any duties from the Constitution to bear this protection on fundamental rights or not? It is difficult because if we look at Central and Eastern Europe, the vertical model remains the starting point in all analyzed systems. And the state and its organs, legislative, executive, judiciary, are treated as a main guarantors of rights. And that follows directly from the idea of the rule of law. And if public powers is exercised on the basis of law, and the law protects the individual, then public authorities are responsible for making rights effective. But what is not, but that is not the whole story. Comparative analysis shows a gradual movement toward mixed models. In several countries, elements of horizontal effect have appeared, sometimes explicitly and sometimes through judicial interpretation. Most often through judicial interpretation. And Croatia is a good example. In Bulgaria, the constitution imposed duties not only on the state but also on individuals. And we can already see combination of vertical and horizontal dimensions. And in Croatia constitutional framework, it is open, recognize the horizontal application of rights, including the relation between private actors. In contrast, in Czech Republic, in Poland, it is more traditional model, and they largely preserve a vertical understanding of rights. And if you know catalogs of these rights and freedoms in the Constitution, how do you think, which kind of these human rights could have this horizontal effect? Do you have I don't know, a right to the court. Is it a right that has horizontal effect? So should we apply to another to give us resolve our case? Rather not. So which kind of this fundamental rights could have this direct effect, horizontal effect? For example, right to privacy. For example, protection of data, protection of the property. Here are some examples that in the judiciary are given as the examples of this horizontal effect of fundamental rights. And between these two poles, we have intermediate solution. So, for example, Slovakia, Romania formally remain closer to the vertical model, but in practice, their cars extend rights into private law relation. And in this system, judicial practice becomes crucial. Constitutional and civil courts balance completing rights between individuals, and in this way they introduce elements of horizontal protection, even in the absence of clear constitutional wording. So what is the broader conclusion? Across Central and Eastern Europe, the protection of rights still depends primarily on the state. But at the same time, we can clearly see a shift towards shared responsibility, especially in the sphere of private right to privacy and protection of data. And fundamental rights are not longer understood only as limits on public power, they are treated as principles that shape social relations more broadly. And what is your opinion? Is it good or not good that this responsibility of protection of human rights is shared between public and private entities? Which for and cons you can find here? So for, please. So the more
democratic protection of fundamental rights can be observed. However, as a con, it at the same time includes who is the responsible.
So thank you. Maybe someone from this part. If you were a legislator, constitution maker, would you use this vertical model or horizontal model relation of the human rights in the Constitution? Try to imagine.
Probably horizontal, because in that case we would have more possibilities.
Thank you. Maybe someone more? Okay, so let's think about it, because it is the question we should cope with, and it is also the question about it, who is the protector on human rights, and what is the role of the state in protection here. Okay, thank you very much, and we have this entities obliged, and now we should consider who is entitled to the protection. So who actually holds fundamental rights? At first glance, the answer seems simple. all analyze that the constitutional systems are based on the principle of universality, and this means that fundamental rights and freedoms are in principle granted to every person, regardless of citizenship, nationality, or legal status. And this universalism reflects a deeper idea that human dignity is the source of rights. But at the same time, this universality is not absolute. Across all analyzed systems, we see a clear distinction between two categories of rights. On the one hand, there are rights granted to everyone, and on the other hand, there is a separate category rights reserved for citizens. What kind of rights are or should be reserved only for citizens, and do you agree with this distinction? So? And here we have these differences between human rights and constitutional rights and freedom. So which kind of rights are, in your opinion, reserved for citizens?
Right to vote.
Okay, voting rights. Right access to public offices as officers holders. So we can together call it political rights. And do you think it is good to share these rights in this way? Or maybe everyone can vote, everyone can be a member of the court, and so on and so on. It is a question about the meaning and role of the citizenship, relation between foreigners and citizens. And it is also the problem because, again, we come here to the question of the rule of law. And what does it mean, rule of law? Rule of law, democratic state ruled by law. So in this region, there are mainly political rights which are reserved for citizens. And there is also another important layer. All analyzed constitutions provide additional protection for specific groups. This reflects both international human rights standards and particular historical and social contexts of each state. Rather than to go through every national system in detail, let me point a few general patterns. In countries such as Bulgaria, Hungary, the constitutional texts include relatively extensive catalogues of specially protected groups. These often include children, families, persons with disabilities, elderly persons, national minorities, combatants. In Czech Republic, the emphasis falls particularly strongly on the equality and non-discrimination, but in each of the constitution of analyzed countries, this equality is important. And the system is strongly universalist, but it also preserves the distinction between universal rights and the citizen political rights. For example, in Poland, we can observe a more balanced model. Usually, rights are granted to everyone, but there is a provision that in some cases the rights can be limited to only to citizens, and the limitation for foreigners should be explained in the statute. So across Central and Eastern Europe, we can identify a consistent dual structure: universal protection on fundamental rights for all individuals, combined with a separate category of citizen rights, mainly a political nature. And at the same time, there is a visible constitutional commitment to protection of specific groups, although the scope and intensity of that protection differ from one system to another. For example, sometimes these provisions are edited as a program norm, not as a right, but what states should do with this kind of group of people. So it is this approach, and it is not only about the people, also these private entities as companies, as association, and so on, are protected under this regime. So, and here also we have this approach the countries used from Convention and jurisprudence of European Court on Human Rights. What is important when we are talking about human rights are guiding principles of the status of the individual. And in Central Europe, that status is not defined only through particular rights and provisions. It also shapes a broader constitutional principles of an axiological nature. And here is the score and the question about common values on which the constitutional system are based. And these principles are not always stated in one place. Sometimes they have to be reconstructed from constitutional texts, preambles, and constitutional jurisprudence. But then we look across the region, a relatively coherent picture emerges, and its center we find four principles: human dignity, freedom, equality, and the rule of law. These are not merely symbolic values, and they play an active role in interpretation and in the practical protection of rights. What is interesting when we analyzing these catalogs of fundamental rights in the constitutions of the region, they are more similar to provision of Universal Declaration of Human Rights and international pacts on human rights of United Nations than on European Convention on Human Rights. But it is because of the membership of in United Nations of these countries before transformation. What about these values? In Bulgaria, these values are reflected in the preamble and then developed in constitutional jurisprudence. And it is the role of the Constitutional Court to shape standards on the basis of this value. Similar tendency exists in Croatia. The Czech Republic offers a slightly different approach. Also, the Charter reflects a stronger natural law orientation, and rights are not understood as something created by Constitution, but as something recognized by it, the same as in Poland, where Article 30 says that the dignity is the base of fundamental rights in Poland. So no, not constitution, but the base is dignity. Romania strongly links dignity with legal certainty and the prohibition of arbitrariness, and in Slovakia, constitutional order combines dignity, freedom, equality, democracy. So in Poland we also have this triad, dignity, freedom, equality, and the sentences in particular constitutions are similar. I think that sometimes the constitution of one country was inspiration for other countries of the region, and it is also explained in the explanation of the constitution. When we research the preparation of the constitution, we can see that in the discussion the earlier constitution of the region were also mentioned. So what we can conclude from this part, despite differences of style and emphasis, an analyzed system converge around the shared axiological core and human dignity, freedom, equality, and the rule of law. They function as operative principles, and they shape interpretation. They limit public power and they influence how rights are protected in practice, and it is the most important again in legislation. So this is a framework of the legislation and should be used in some parliaments before starting procedure. Special committees of the parliament have power to check if the bill is in accordance with general principles of human rights, so with the dignity, freedom, and with equality. And this committee could recommend to the marshal not to start proceeding with the bill on the basis on it. Catalog on fundamental rights, I've just said something about it, but we should know that in all Central and Eastern European states, this catalog forms a central part of the constitutional legal order. They are rather in the beginning, despite some structural differences, they generally follow a similar pattern. Most constitutions distinguish between civic rights, political rights, economic, social, and cultural rights. Do you see any similarities with something? So this civic rights, personal, political rights, economic, social, and cultural rights. Any reminiscence? Please, Professor. United Nations international pacts. First pact is about civic and political rights, and second is about economic, social, and cultural rights. So this division, and as we come back to the theory of human rights law, we know about this generation of human rights. So first we, in this catalog, we have the first generation, so personal, political rights, and second generation economic, social, and cultural rights. Of course, you can read about it in these all books which were presented here. At the same time, many of them have gradually incorporated new categories of rights, such as environmental rights or minority rights, so third generation rights. And so here we can clearly see both continuity and evolution. Bulgaria regulates rights in a dedicated constitutional chapter and distinguishes in the practice between absolute and relative rights. Croatia offers a particular extensive catalogue with strong emphasis on procedural guarantees, especially right to a fair trial. In Czech Republic, I mentioned the Charter provides highly structured and comprehensive system rights, including minority rights and right to asylum. Hungary is different than others because here are freedom and responsibility. In Poland, we have rights, freedoms, and duties. Romanian combines a catalogue of rights with explicit guarantees of protection. Slovakia is similar, and in Slovenia, all generations of rights also are covered. And even through formal hierarchy are usually absent, constitutional practice across the region points to a special importance core rights. This includes human dignity, right to life, or protection of life, legal protection of life, freedom of expression, procedural guarantees as right to a free trade. And so the general conclusion of it is this catalog shows a high degree of convergence and then combine international standards with national constitutional traditions. And because of these experiences of communistic period, these catalogs are extended. Today, there is a question if you need to expand it more. But, as I mentioned, rights, fundamental rights are not absolute. So sometimes there are legal reasons to limit of practicing these rights. And it is not that we reject or cancel these rights, but we can, in legal way, limit the use of them. So all constitutional systems in Central and Eastern Europe allow rights to be limited. And again, it is rather not limitation of rights, but practicing of rights, because we don't reject these rights. But this limitation, legal limitation, could be done only under strict condition. And across the region, the general structure is quite similar. Any restriction must have a legal basis, so it should be done especially in a Parliamentary Act. During pandemic, there was a huge discussion if, for example, government could limit exercising human rights without basis in the statute, Parliamentary Act. And also it should be necessary in the democratic state ruled by law, and it should be in accordance with some values. So any restriction must have legal basis, pursue a legitimate aim, and comply with principle of proportionality. And the limitations must not violate the essence of the right, and this concept of the essence of right is from German theory. And it is implemented to this constitution. This is particularly important shared standard. The exact wording differs from the state to state, but the core logic remains the same. In Bulgaria, proportionality is not always explicitly formulated in constitutional text, but it's clearly present in doctrine and case law, and it is case law where the test of proportionality is formulated. So constitutional courts formulate test of proportionality. It is very useful to check if the limitation is in accordance with constitution with human rights. Croatia has more explicit general limitation clause. In Czech Republic, it is strongly dependent of constitutional court. In Poland, it is very clear formula. And also in Poland, the values for which we can limit human rights are done. It is public security, public order, protection of the environment, public health, morality, and also rights and freedoms of others. So it is the explanation when, in the substantive approach, we legislator could limit using, practicing human rights. So despite the differences in form, the underlying approach is very similar. Sometimes the method is that in particular right, there's limitation clause, and it is also visible in this legal elements. In Poland, for example, sometimes it is a problem because we have general clause and also this particular clause, for example, in limitation of religious freedom, limitation of property, and it is the question, should we treat it as lex specialis via legi generali or something different? And Constitutional Tribunal of Poland said that they are complex, so we should use both because in dubio pro libertate, so if we have any doubts, we should follow in favor of human rights and protection of the fundamental rights. And of course, proportionality functions as a central standard for balancing rights and public interests. It is also common principle in the EU and in jurisprudence of European Court on Human Rights. And these limited clauses play a double role. They allow the state to interfere where that is justified, but at the same time they protect the individual by assuring that any interference remains lawful, necessary, and controlled. So I said in the beginning that these clauses are important when we are making law, but it is also important when we adjudicated law, for example, in front of the constitutional courts after it is in force. And now something different, because these constitutions of the region were prepared after the period of transformation, but now we have to face with some new challenges, as it was also mentioned during the first session. How to reconcile stability with adaptability? Constitutions are meant to be stable. and they provide community, but at the same time they must respond to changing realities. Which kind? Digitalization, migration, social transformation, environmental concerns, cultural pluralism, threats of the security, and this tension appears not only in constitutional text but very often in constitutional interpretation. And what is your opinion? Should we amend or change constitution because of the challenges of modernity, or should we use the constitution and as a living instrument and interpret it in accordance of the times? What approach is better and is in accordance with the rule of law, in your opinion? For example, we have now this question about using AI. So it is the problem of the right to property, and so on and so on. So do you think that we need digital human rights, or we can interpret this classical right to privacy, right protection of property, but in this modern way? So please. Mm-hmm.
The law, and we can interpret this under these articles.
So here's the question. Thank you very much. Here's the question: when interpretation starts to be legislation, and do we have competencies to change constitution without changing it? Right to internet, right. For example, if in constitution is not, we don't have the right to clear environment, should we put it to the constitution, or maybe from this classic first generation rights we can interpret them in accordance of this new challenge?
Everything that could be under the constitution, but also in different countries how can be changed. Constitution varies, and how strong or not as strong constitutions vary between the countries, mm-hmm. And it is hard to change constitution just for this reason, just to add these mm-hmm. things, because in my opinion most of them can be interpreted, and if it's something that is necessary, yes, we can, but in the big picture, just to include everything under it, in my opinion, it is better to go to the other way and to try to implement mm-hmm. to yes.
Thank you. For example, sometimes the protection of environment is connected with right to privacy, protection of health, and so on, as it does European Court of Human Rights today. And maybe this living instrument here could be used also for the Constitution. Thank you very much for your voice in this matter. And the Constitution of the region are relatively modern sometimes. But, for example, in Poland, we have this right to information of the environment, right to protection of data, and Constitution of Poland was enacted in 1997, so before RODO and all these elements, but the constitution maker had imagination of these challenges. Not ever, but they had. I know that we should soon start, only 10 minutes left. So the right to a court and the right to an effective remedy. Catalogs of rights are not full when we don't have the procedures, because declaration is only declarations, and we should have a system of the organs and the procedures to effective protection. So the right to the court and the right to effective remedy, it is most important thing here. These rights are essential to the rule of law, because without them all other rights becoming theoretical. And their core meaning is strongly shaped by international law. Across Central and Eastern Europe, we can see a strong degree of convergence in this area, although some national differences remain. In Bulgaria, the constitution does not formulate the right to a court in explicit terms, but constitutional jurisprudence clearly recognizes it as a part of the rule of law. And even if it is not written in the constitution, it derives from the rule of law. But in other countries, this rule of law, right to the court, fair trial, right to application is clearly written in the provision. So all analyzed system recognize the right to a court and the right to an effective remedy. Not always effective remedy is right to the court, because sometimes, in particular cases, better is to make other structures, and right to the court is ultimum ratio, so it is treated on the subsidiarity way. The differences concern mainly the level of constitutional detail and the role of the constitutional courts, but across the whole region we can see a clear movement from formal concept to access to justice towards a broader idea of effective judicial protection. And I think that after break there will be something about that on the basis on these standards. And to the end, I have a few words about civic duties, because in this constitution of the region, very often the civic duties are combined in the chapter with fundamental rights, and these fundamental rights does not exist in isolation in the constitutional system of the region. They are usually accompanied by a set of civic obligations. Some of these obligations are for everyone, and some only for the citizens. And across Central and European Europe, civic duties operate as a normative counterpart to rights and as a part of constitutional democracy. And it is about responsibility. And to conclude, the protection of fundamental rights in Central and Eastern Europe reflects two parallel developments. On the one hand, we can see growing maturity of this constitutional system, and it is thanks to constitutional courts, because it is the main organ who develop this meaning of human rights, fundamental rights. On the other hand, we can see their gradual convergence toward common European standards, and despite differences in history and constitutional traditions, all analyzed systems share a common axiological foundation, theoretically, and its center are four basic principles: rule of law, human dignity, freedom, and equality. These principles remain the main reference point across the region. The key findings: first, in all analyzed states, the Constitution remains the primary source of the rights protection. At the same time, constitutional protection is increasingly supplemented and sometimes strongly shaped by international law. And second, although terminological differences remain, the concepts of human rights, fundamental rights, and constitutional rights converge in practice. The structure of protection is evolving. The traditional vertical models are complemented by horizontal effects, but it is the result of the judiciary. Proportionality across all analyzed systems, it functions as a central standard for limiting rights, and here constitutional and supreme courts play a decisive role. And at the same time, this system faces new challenges. States respond to those challenges in different ways. And analyzed systems combine universalist approach to the rights with differentiated protection for specific group and distinct category of citizens' rights. The broader conclusion is, despite structural and doctrinal differences, constitutional system in Central and Eastern Europe are moving towards more coherent model of right protection and more based on shared values, multi-level legal protection. So not monism, not dualism, but this openness for international law, and increasingly integrate European context. And the future of this model will depend not only on the constitutional text, but also on judicial interpretation and legislative practice. And also here is the role of civil society and academia to shape these rights in right direction. And I don't know if it works, but if you have 2 minutes, could you use your mobile phone and scan this QR text? I hope it. Unfortunately, we don't have access, but I have here, so I don't know how to. Excuse me. Can I share the screen with my screen? Could be shared, or maybe they can. So let's make it in a different way. Yes. Yes. Start. Dobra. I will read it, and you have to. Which statement the best describes this relationship between human rights and fundamental rights? They always mean exactly the same. They are often used interchangeably but may differ in legal meaning. They apply only in international law. They always have different meanings. First, the same, change they often change interchangeably, yes. So most of you click good way. It does not work, the connection, unfortunately. Second, what does the absence of formal hierarchy of rights mean? All rights are absolute. Some rights may still have special importance. In practice, all rights are equal. The hierarchy is decided by Parliament. What does the absence of formal... Some rights may still have special importance in practice. Which element is not required when limiting fundamental rights? Legitimate aim, legal basis, proportionality, citizen consent. Legitimate aim, legal basis, proportionality, citizen consent. Not required when limiting fundamental rights. Okay, citizens consent. And the last one. What does the horizontal effect of fundamental rights mean? They are applied only by constitutional courts, they apply only to the state authorities, they apply only in the international relations, they also affect relationships between private individuals. Perfect. Okay, so thank you very much. Thank you for... Kto wygrał? Who was the best? Moment. One moment, please. Number one. Donkey with something on the head. And second, NRS. Third, key point EE. Fourth place, L.R, and fifth place, number 5. So congratulations, thank you very much. And thank you for your participation and have a nice day. Bye.